Hello, and welcome to our comprehensive guide on understanding the tax grievance process in the United States. Over the next several chapters, we will explore the intricate world of property taxes, assessments, and what it means to formally challenge your property's valuation. Our goal is to provide you with clear, educational information to help you understand this complex topic. Before we begin, it is absolutely essential to state the following. The information provided in this entire series is for educational and informational purposes only. It is not intended to be, and should not be construed as legal, financial, or tax advice. Property tax laws and procedures vary significantly by state, county, and even municipality. You should always consult with a qualified professional, such as a tax attorney or a certified public accountant, for advice tailored to your specific situation. This series does not create any kind of professional-client relationship. Now let's lay the groundwork. For millions of homeowners across the United States, receiving a property tax bill is a routine, yet often stressful, part of life. It's one of the largest expenses associated with owning a home. But have you ever stopped to truly understand what that bill represents and where those numbers come from? To understand a tax grievance, we must first understand the system it seeks to challenge. So what exactly is a property tax? At its core, a property tax is a levy on real estate. This tax is the primary source of funding for local governments. The money collected from property taxes pays for essential community services that we often take for granted. Think about the public schools your children might attend, the fire department that protects your home, the police officers who ensure public safety, the maintenance of local roads you drive on every day, and the upkeep of public parks and libraries. Without property taxes, these vital local services would be severely underfunded or non-existent. The key thing to remember is that property taxes are inherently local. They are not collected by the federal government, like your income tax. Instead, they are administered by counties, cities, towns, and school districts. This is precisely why the rules, rates, and procedures can be so different from one town to the next, even if they are just a few miles apart. This brings us to two critical players in the property tax world: the tax assessor and the tax collector. Many people use these terms interchangeably, but they have distinctly different roles. Understanding this difference is the first step in understanding the grievance process. The tax assessor's job is to determine the value of your property for taxation purposes. This is a crucial role. The assessor is a government official who inspects properties, reviews market data, and uses established methods to assign a value to every piece of real estate within their jurisdiction. This value is known as the assessed value. The assessor does not set the tax rate, nor do they collect the taxes. Their sole function is valuation. The tax collector, on the other hand, is responsible for the billing and collection of the taxes. They take the assessed value determined by the assessor, apply the tax rates set by various government bodies like the school board and town council, and then send you the bill. If you have an issue with the amount of money you owe or how it was collected, you would speak to the collector. But if you have an issue with why you owe that amount because you believe your property's value is incorrect, your focus is squarely on the assessor's office. Let's dive a little deeper into the concept of assessed value. The assessed value is not necessarily the same as the market value of your home. Market value is what your home would likely sell for on the open market. Assessed value is simply the value used for tax calculations. In some areas, the assessed value is a certain percentage of the market value. For example, a home with a market value of $500,000 might have an assessed value of 80% of that, which would be $400,000. This percentage is often called an assessment ratio, or equalization rate. The goal of the assessor is to ensure that all properties are valued uniformly and fairly, so that the tax burden is distributed equitably among all property owners. So where does a tax grievance come into play? A tax grievance, also known as a property tax appeal, is a formal process that allows a property owner to challenge the assessed value of their property. It is your legal right to do so. A grievance is a claim that the assessor has made a mistake in valuing your property. It's an argument that your property's assessed value is inaccurate, unfair, or inequitable. This leads us to the single most important concept to grasp in this entire chapter. When you file a tax grievance, you are not appealing your tax bill itself. You are not arguing that your taxes are too high. You are not challenging the local school budget or the tax rate set by your town. Everyone in your jurisdiction pays the same tax rate. Instead, you are making a very specific claim. You are arguing that the assessed value of your property is incorrect. Your entire case is built on proving that the value the assessor has placed on your home is greater than it should be. The logic is simple. If you can successfully argue for a lower assessed value, and the tax rate remains the same, your resulting tax bill will be lower. Think of it like a simple formula. Assessed value multiplied by the tax rate equals your tax bill. You cannot change the tax rate through a grievance. The only variable you have the power to challenge is the assessed value. So, why might an assessment be incorrect? There are several reasons. The assessor might have incorrect information about your property. Perhaps they have it listed with 4 bedrooms when it only has 3, or they believe you have a finished basement when it is unfinished. Valuing property is also not an exact science, it is an estimate. The assessor may have overvalued your property relative to similar properties in your neighborhood. Or perhaps the market value of properties in your area has declined, but your assessment has not been adjusted accordingly. These are the kinds of arguments that form the basis of a tax grievance. To summarize this introductory chapter, a property tax is a local tax on real estate that funds essential community services. The tax assessor determines your property's value for tax purposes, known as the assessed value. The tax collector then uses that value to calculate and send your bill. A tax grievance is the formal process of challenging that assessed value, not the tax rate or the amount of your bill. It is your opportunity to present evidence and argue that your assessed value should be lowered, because it is inaccurate or unfair. In our next chapter, we will delve into the specific grounds for filing a grievance. We will explore the common legal arguments you can make, such as excessive assessment, unequal assessment, and unlawful assessment, and what each of these terms means in practical, easy-to-understand language. Thank you for joining us. Welcome back to our educational series on the property tax grievance process in the United States. In our first chapter, we established a crucial foundation. A tax grievance is a formal challenge to your property's assessed value, not a complaint about your tax rate or the size of your tax bill. Before we proceed, we must reiterate our disclaimer. The content in this chapter, and throughout this series, is for informational and educational purposes only. It is not legal, financial, or tax advice. Property tax laws are highly localized and complex. For guidance on your specific circumstances, it is essential to consult with a qualified professional, such as a tax attorney or a certified assessment consultant. So you've reviewed your property assessment, and something feels off. You have a gut feeling that the value is too high, but a feeling isn't enough to build a case. A successful grievance needs a solid legal basis. In the world of property tax appeals, these legal bases are known as the grounds for a grievance. While the specific terminology can vary slightly from state to state, most jurisdictions recognize 4 primary grounds for challenging an assessment. Think of these as the 4 pillars upon which a formal appeal is built. They are excessive assessment, unequal assessment, unlawful assessment, and misclassification. Let's break down each of these pillars one by one. The first, and perhaps most common, ground is excessive assessment. This is the most straightforward concept for homeowners to grasp. An excessive assessment claim argues that the assessed value of your property is simply greater than its full market value. In essence, you are saying, the government has valued my home for more than it is actually worth. To make this argument, you first need to understand what market value means. The generally accepted definition is the price a property would sell for on the open market, assuming a willing buyer and a willing seller, with neither being under any compulsion to buy or sell. It's the fair price that your home could realistically command. So, if your home is assessed at $500,000, but you have strong evidence showing that its true market value is closer to $425,000, you may have grounds for an excessive assessment claim. There's also a second, less common form of excessive assessment. This occurs when you believe you were denied a property tax exemption you were legally entitled to, or that the exemption was calculated incorrectly. For instance, many jurisdictions offer partial exemptions for seniors, veterans, or individuals with disabilities. If you applied for and qualified for such an exemption, but it wasn't correctly applied to your assessment, this would also fall under the umbrella of an excessive assessment. The second pillar is unequal assessment. This ground is more complex to understand and often more difficult to prove, but it is just as valid. An unequal assessment claim doesn't necessarily argue that your home is valued for more than it's worth. Instead, it argues that your property is assessed at a higher percentage of its market value compared to the average of all other properties in your assessing unit, or compared to similar properties on the same assessment roll. This is about fairness and equity. The principle is that the tax burden should be distributed proportionally. Let's use a simple analogy. Imagine you and your neighbor have identical houses, built by the same builder in the same year with the same features. In a fair system, your assessments should be identical or very close. If your home is assessed at $500,000 but your neighbor's identical home is assessed at $400,000, you may have a case for an unequal assessment. To prove this, you often need to show a consistent pattern. You would need to demonstrate that, on average, properties in your area are assessed at, say, 85% of their market value, while your property is being assessed at 95 or 100% of its market value. Proving this typically requires a significant amount of data and analysis of comparable properties, which is why it can be a more challenging path to take. The third pillar is unlawful assessment. This is a claim that your property's assessment violates a specific law. It's not about the value of the property, but about whether the assessment should have been made at all, or if it was made correctly according to legal statutes. This ground applies in very specific situations. For example, certain types of properties are wholly exempt from property taxes. These often include properties owned by religious organizations, government entities, nonprofits, or educational institutions. If a church, for instance, received a property tax assessment, that assessment would be considered unlawful because the property is legally exempt from taxation. Another example of an unlawful assessment is when a property is assessed by a town or county that doesn't actually have the jurisdiction to do so. If your property is located entirely within Town A, but you receive an assessment from neighboring Town B, that assessment is unlawful. Finally, an assessment could be deemed unlawful if it was not created in accordance with the procedural requirements of the law, such as being placed on the wrong portion of the assessment roll. The fourth and final pillar is misclassification. In many jurisdictions, properties are categorized into different classes, such as residential, commercial, industrial, or vacant land. These classifications are important because different classes can be subject to different tax rates or assessment ratios. A misclassification claim argues that your property has been placed in the wrong category. For instance, if you own a two-family home that is used purely for residential purposes, but it has been classified as a commercial property, you would have grounds for a misclassification grievance. Correcting the classification can have a significant impact on your final tax liability. So, to review, the four main pillars or grounds for a tax grievance are: excessive assessment, because your property is valued for more than it's worth; unequal assessment, because your property is assessed at a higher percentage of its value than others; unlawful assessment, because the assessment itself violates the law; and misclassification, because your property is in the wrong category. Understanding which of these grounds applies to your situation is the critical next step after receiving your assessment notice. It will define the type of evidence you need to collect and the argument you will ultimately present. In our next chapter, we will transition from the why to the how. We will discuss the first practical steps in the grievance process, starting with the crucial task of gathering the right evidence to support your claim. Thank you for listening. Hello and welcome back. In our previous chapters, we defined what a tax grievance is and explored the four primary legal grounds for filing one: excessive, unequal, unlawful, and misclassified assessment. Now we move from theory into practice. A successful grievance is not one on feelings or opinions. It is one with credible, compelling evidence. This chapter will focus on the types of documentation and information that are typically used to build a strong case. As always, we must begin with our important reminder. This information is for educational purposes only and should not be considered legal or financial advice. The specific evidence required and the weight given to it can vary significantly depending on your local jurisdiction's rules and procedures. Always consider consulting with a qualified tax grievance specialist or attorney who understands the specific requirements in your area. The very first step in gathering evidence is to become an expert on your own property, at least as far as the government's records are concerned. You need to obtain a copy of your property record card, sometimes called an assessment card or worksheet. This document is the foundation of your assessment. It is the official record held by the assessor's office, detailing what they believe to be true about your property. This card contains a wealth of information: the lot size, the square footage of your home, the number of bedrooms and bathrooms, the age of the structure, details about a garage, a deck, a fireplace, a swimming pool, and the home's general condition. Your first task is to review this card meticulously for errors. Are there any factual inaccuracies? Does it say you have a finished basement when it's just a concrete slab? Does it list central air conditioning that was never installed? Does it overstate your home's square footage? Any discrepancy, no matter how small, can be a crucial piece of evidence, because it proves that the assessment was based on flawed data. Correcting these factual errors is often the simplest path to a reduction in assessed value. Once you've verified the physical details, the next step is to gather evidence related to your property's market value. This is especially critical if you are claiming an excessive assessment. The central question you need to answer with evidence is, what was my property worth on the valuation date? The valuation date is a specific date set by the assessing unit each year, and it's important to focus your evidence around that time frame. One of the most powerful forms of evidence for proving market value is data on comparable sales, often referred to simply as comps. This involves identifying recent sales of properties that are as similar to yours as possible, in the same or a very similar neighborhood. The ideal comparable property would have the same architectural style, a similar age, comparable square footage, the same number of bedrooms and bathrooms, a similar lot size, and be in a similar overall condition. When looking for comps, the timing of the sale is critical. You generally want to find sales that occurred as close as possible to your jurisdiction's valuation date. A sale from 3 years ago is far less relevant than one from 3 months ago. You will want to gather data on at least 3 to 5 strong comparable properties that sold for less than your home's assessed value. For each comp, you should document the property address, sale price, date of sale, and key features. You may find this information through public records available from your county clerk's office, from local real estate professionals, or through various online property databases. Another highly persuasive piece of evidence is a professional appraisal. An appraisal is a formal, written opinion of your property's market value, prepared by a state-licensed or certified appraiser. The appraiser will conduct a thorough inspection of your home, research recent comparable sales, and use their professional expertise to determine a value. While this does come at a cost, an appraisal from a respected professional can carry significant weight in a grievance hearing because it represents an unbiased, expert opinion. If you do get an appraisal, ensure the appraiser is aware that its purpose is for a tax grievance, so they can focus on the correct valuation date. What if your claim is based on unequal assessment? The evidence required here is more complex. You are not just proving your home's value. You are trying to prove that your assessment is unfair relative to others. This often requires a more sophisticated analysis. You might need to gather the assessment data for a large number of properties in your area, and compare their assessed values to their recent sale prices to establish an average assessment ratio. You would then compare your own property's assessment ratio to that average. This can be a data-intensive process, and is often where professional assistance becomes particularly valuable. For claims of unlawful assessment or misclassification, the evidence shifts from market data to legal and official documents. For an unlawful claim, you might need a copy of your property's deed to show it's outside the jurisdiction, or documentation proving your organization's tax-exempt status. For a misclassification claim, you might use zoning maps, building plans, or photographs to demonstrate that the property's use does not match its assigned class. Regardless of the grounds for your claim, photographs are an invaluable tool. Take clear, recent pictures of your property. If your home has issues that negatively impact its value, such as a leaky roof, a cracked foundation, or significant deferred maintenance, document them with photos. Also, take photos of the exterior and interior to accurately represent its current condition. To summarize, building your case means moving beyond feelings and into facts. Start by obtaining and verifying your property record card. Then, depending on your grounds, gather evidence like comparable sales data, a professional appraisal, photographs, and other official documents. Organize this information clearly and logically. In our next chapter, we'll walk through the administrative steps of actually filing the grievance, from finding the right forms to meeting the critical deadlines. Thank you for joining us. Welcome back. In our last chapter, we detailed the critical process of gathering evidence to build a solid case for your property tax grievance. But even the most compelling evidence is useless if it isn't submitted correctly and on time. This chapter is all about the administrative side of the process, the paperwork, the deadlines, and the formal act of filing your grievance. As we move into these procedural details, our standing disclaimer is more important than ever. The information provided here is a general overview for educational purposes, and is not a substitute for professional legal or tax advice. Filing procedures, forms, and especially deadlines are dictated by local law, and can vary dramatically from one municipality to another. It is your responsibility to verify the specific requirements and dates for your exact location. The grievance process doesn't just begin whenever you feel like it. It operates within a very specific, legally mandated calendar. The starting gun for this process is typically the publication of the tentative assessment roll. This is a preliminary version of the property tax roll for the upcoming year, which lists the proposed assessed value for every property in the jurisdiction. Shortly after this roll is published, Property owners whose assessments have changed will usually receive a notice of change of assessment in the mail. This notice is your official alert that the value of your property for tax purposes may have been adjusted. This is the moment to pay close attention. The publication of the tentative roll opens a window of time during which you can file a formal grievance. This window closes on a very specific date, often referred to as Grievance Day, or simply the filing deadline. Let's be unequivocally clear on this point. This deadline is absolute and non-negotiable. If you miss it, even by one day, you will almost certainly lose your right to challenge your assessment for that entire tax year. You will have to wait until the following year to try again. Finding out the exact filing deadline for your city, town, or county is the single most important administrative step you will take. This date is public information and can typically be found on your assessment notice, on the website of your local assessor's office, or by calling them directly. Once you know your deadline, the next step is to obtain the official grievance application form. You cannot simply write a letter. You must use the specific form required by your assessing unit. In many parts of the country, this form is known by a specific number, such as the RP 524 form in New York State, but the name will vary. These forms are usually available for download from the local government or assessor's website. You can also typically pick one up in person at the assessor's office. This application form is a legal document, and it must be filled out completely and accurately. The form will ask for basic information, such as your name, the property address, and its parcel identification number, which you can find on your tax bill or assessment notice. The most critical section of the form is where you state the grounds for your grievance. You will need to indicate why you believe your assessment is incorrect, typically by checking a box for excessive, unequal, unlawful, or misclassified. As we discussed in Chapter 2, the form will then require you to state what you believe the correct total value of your property should be. This is a crucial number. You must provide a specific value, as you cannot simply write lower or to be determined. This is where the evidence you gathered in the previous chapter comes into play. The value you enter should be a figure you can confidently support with your comparable sales data, professional appraisal, or other documentation. Once the form is completed, you must sign it. Then you will package it together with all the evidence you have prepared. This includes copies of your property record card with corrections noted, your list of comparable sales, the full appraisal report if you have one, photographs, and any other supporting documents. It is advisable to make a complete copy of the entire package, the application form and all attachments, for your own records before you submit it. The final step is the submission itself. You must deliver the grievance application and your evidence to the correct office by the deadline. This is usually the assessor's office or the Board of Assessment Review. Common submission methods include hand delivering it, sending it by mail, or in some jurisdictions, filing it electronically. If you deliver it in person, it is a very good practice to take your personal copy with you and ask the clerk to stamp it with the date it was received. This stamped copy is your official proof that you filed on time. If you send it by mail, it is highly recommended to use a method that provides proof of delivery, such as certified mail with a return receipt requested. This receipt will serve as your proof that the package was sent and received before the deadline. To recap the administrative process, you must first identify the critical filing deadline in your locality, which occurs after the tentative assessment roll is released. Obtain, complete, and sign the official grievance application form. Attach clear copies of all your supporting evidence. Finally, submit the complete package to the proper office before the deadline, and be sure to get proof that you did so. Now that your grievance is officially filed, what happens next? In our next chapter, we will explore the review process and what to expect during the hearing before the Board of Assessment Review. Thank you for listening. Hello, and welcome back to our series on navigating the property tax grievance process. You've done the hard work. You've analyzed your assessment, identified your grounds for a grievance, gathered your evidence, and filed your application on time. Now, you've received a notice scheduling your hearing. This chapter will demystify that hearing, explaining who you'll be meeting with and how to effectively present your case. Before we dive in, we must restate our essential disclaimer. This chapter provides general educational information about the hearing process and does not constitute legal advice. Procedures can vary significantly between jurisdictions. For specific guidance, you should always consider consulting a qualified professional who is familiar with the process in your local area. After you file your grievance, your case is scheduled to be heard by a body known as the Board of Assessment Review, often abbreviated as BAR. So what is this board? The Board of Assessment Review is an impartial panel of local citizens appointed to hear and decide on property tax grievances. They are not employees of the assessor's office. Their role is to act as an independent tribunal, listen to both the property owner and the assessor, and then make a fair and objective determination based on the evidence presented. The board typically consists of 3 to 5 members from your community. The purpose of the hearing is to give you an opportunity to explain, in your own words, why you believe your property's assessment is incorrect. It is also the assessor's opportunity to defend their valuation. It's important to understand that the hearing is an administrative proceeding, not a formal court trial. The rules of evidence are more relaxed, and the atmosphere is generally less intimidating than a courtroom. However, it is still a serious, quasi-judicial process, and you should treat it with respect. A common question is, do I have to attend the hearing in person? The answer depends on your local rules. In many places, your attendance is not mandatory, especially if you have submitted a well-documented case. The board will review the evidence you provided and make a decision based on that written submission. However, attending the hearing is almost always a good idea. It allows you to answer any questions the board may have, clarify points in your evidence, and ensure your argument is fully understood. It personalizes your case and shows the board that you are serious about your claim. Preparation is the key to a successful hearing. You should not be scrambling to find documents moments before you speak. Organize all your paperwork into a logical order. A simple folder or binder with tabs for your application, your property record card, your comparable sales analysis, photos, and your appraisal can be incredibly helpful. Prepare a brief, clear opening statement. This should be a 2 to 3 minute summary of your position. State your name, your property address, the current assessed value, the value you believe is correct, and the primary reason for your request. For example, my assessment is excessive based on recent comparable sales. When your case is called, you will typically sit at a table facing the board members. The assessor, or a representative from their office, will also be present. The chairperson of the board will likely begin by explaining the procedure. Generally, you, the property owner, will be invited to speak first. This is your time to shine. Speak clearly and calmly. Stick to the facts of your case. Avoid emotional arguments about how high your taxes are or complaints about local government spending. Remember, the board has no control over tax rates or budgets. Their sole focus is on the fairness and accuracy of your property's valuation. Walk them through your evidence, piece by piece. For example, you might say, as you can see from my property record card, the assessor has me listed with 2,500 square feet, but as my attached building sketch shows, the actual size is 2,200 square feet. Or, I have provided details on 3 comparable homes in my neighborhood that all sold for between $400,000 and $420,000 in the past 6 months, which supports my belief that my assessment of $500,000 is excessive. After you have presented your case, the assessor will have a chance to respond. They may present their own evidence to support their valuation, such as a different set of comparable sales. They might also ask you questions about your property or the evidence you submitted. After the assessor speaks, the board members may ask questions of both you and the assessor to clarify any points they are unsure about. Answer their questions honestly and directly. If you don't know the answer, it is perfectly acceptable to say so. Throughout the entire process, your demeanor is critical. Be polite and respectful to everyone in the room, including the board members and the assessor. Even if you strongly disagree with the assessor, maintaining a professional and courteous attitude will reflect positively on you and your case. The board will not usually make a decision on the spot. They will hear all the cases scheduled for that day and then deliberate in private. You will be notified of their decision in writing, typically within a few weeks. This notification is a formal document, often called a notice of determination. To summarize, the hearing is your chance to make your case in person before an impartial board. Prepare by organizing your evidence and a short opening statement. When you speak, be clear, factual, and respectful. Answer all questions honestly. In our next chapter, we will discuss what happens after you receive the board's decision and explore your options if you are not satisfied with the outcome. Thank you for listening. Hello and welcome back. In our previous chapter, we walked through the process of presenting your case at a hearing before the Board of Assessment Review. You've made your arguments and submitted your evidence. Now comes the waiting period, followed by a formal decision. This chapter will cover the possible outcomes of your hearing and, crucially, what you can do if the decision is not in your favor. As we are now entering into a discussion of further legal proceedings.
Disclaimer. This video is for informational and educational purposes only. and should not be considered professional legal, financial, or tax advice. I am not a certified public accountant, CPA, or a tax attorney. You should consult with a qualified professional for advice tailored to your individual situation. Tax laws are complex and subject to change. The creator of this video or the channel will not be held liable for any actions taken based on the information provided.
Our disclaimer is of the utmost importance. The information presented here is for general educational purposes only. It is not, and should not be interpreted as legal advice. The options for appealing a decision from the Board of Assessment Review involve formal legal actions with strict deadlines and procedural rules. It is strongly recommended that you consult with a qualified attorney specializing in property tax matters to understand your rights and options. Sometime after your hearing, typically within a few weeks to a month, you will receive a written decision from the Board of Assessment Review. This official document is often called a Notice of Determination. You should read this document very carefully. It will inform you of the board's final decision on your grievance. There are generally 3 possible outcomes. The first outcome is a full success. The board may grant the exact reduction you requested, lowering your assessed value to the amount you proposed in your application. If this happens, congratulations. Your work is done for the year. The assessor's office will be instructed to amend the assessment roll, and your future tax bills for that year will be calculated based on this new, lower value. The second outcome is a partial success. The board might agree that your assessment was too high, but not as high as you claimed. They may offer a partial reduction, lowering your assessment to a value somewhere between the original assessment and the value you requested. You will then have to decide if this partial reduction is acceptable to you. The third outcome is a denial. The board may find that you did not provide sufficient evidence to warrant a change, and they will uphold the original assessment. This can be disappointing, but it is important to remember that this is not necessarily the end of the road. If your grievance is denied, or if you are unsatisfied with a partial reduction, you generally have the right to seek judicial review. This means you can take your case to the next level in the state court system. While the specific names and procedures vary by state, there are typically 2 main paths for a judicial appeal. The most common path for homeowners is a process known as Small Claims Assessment Review, often abbreviated as SCAR. SCAR is a special, simplified court proceeding designed to be more accessible and less costly for the average homeowner. It is typically restricted to owner-occupied residential properties, although the exact eligibility rules differ by state. When you file a SCAR petition, you are essentially asking a court-appointed, impartial hearing officer or judge to hear your case all over again. This is what's known as a de novo review, which means from the beginning. The hearing officer is not there to simply review the board's decision for errors. They are there to look at all the evidence with a fresh set of eyes and make their own independent determination of your property's value. You will present your evidence, and the municipality will present theirs, much like in the board hearing but in a slightly more formal setting. Filing a SCAR petition involves submitting a formal petition to the county court, paying a small filing fee, and ensuring all relevant parties, including the assessor and school district, are properly notified. The other, more traditional method of judicial review is often called a tax certiorari proceeding. This is a much more formal and complex legal action under a state's property tax law. It is available for all types of property, including commercial, industrial, and high-value residential properties. Unlike SCAR, a tax certiorari proceeding follows the standard rules of civil litigation. It can involve formal discovery motions, and potentially a full trial before a judge. Because of its complexity and expense, this path is almost always pursued with the guidance of an experienced attorney, and is generally not the preferred route for a typical homeowner's grievance. It is absolutely critical to understand that both of these appeal options have very strict filing deadlines. Typically, you will have a very short window of time, often only 30 days, from the date you receive the board's final determination to file your petition with the court. This is a hard deadline. If you miss it, you lose your right to appeal for that year. To summarize, after your hearing, you will receive a formal written decision. If your grievance is granted, your assessment will be lowered. If it is denied or only partially granted, you may have the right to a judicial appeal. For most homeowners, this means filing a petition for a Small Claims Assessment Review, or SCAR. This next step is a formal legal process, and it is highly advisable to seek professional legal counsel to navigate it correctly and ensure you meet all the critical deadlines. In our next chapter, we will take a closer look at the role of professionals in the tax grievance process, when and why you might consider hiring an attorney or a specialized tax consultant. Thank you for listening. Hello and welcome back. Throughout this series, we have broken down the property tax grievance process, from understanding your assessment to filing an appeal after an unfavorable decision. This naturally leads to a very practical question. Can I do this myself, or should I hire a professional? This chapter is dedicated to exploring the roles of the experts who specialize in this field, helping you understand what they do and when you might consider seeking their help. As we discuss hiring professionals, it is vital to remember our foundational principle. This content is for educational purposes only, and is not a recommendation or endorsement of any particular service or professional. The decision to hire an expert is a personal one that depends on your individual circumstances, the complexity of your case, and your comfort level with the process. This is not legal or financial advice. Many homeowners successfully navigate the initial grievance process on their own, particularly if their case is straightforward. For example, correcting a simple factual error on a property record card. The do-it-yourself approach can be empowering and, of course, saves you the cost of professional fees. However, there are situations where the expertise of a professional can be invaluable. Let's discuss the different types of professionals you might encounter. The most common are tax grievance consultants or representatives. These are specialists who focus exclusively on property tax assessment appeals. They are not always attorneys, but they possess deep knowledge of property valuation principles, local real estate market conditions, and the specific procedures of the Board of Assessment Review. A good consultant lives and breathes this process. They know what kind of evidence the board finds persuasive, and how to present it effectively. When you hire a consultant, they typically handle the entire process for you. Analyzing your assessment, gathering comparable sales data, preparing and filing all the necessary paperwork, and representing you at the hearing. A related but distinct professional is a state-licensed or certified appraiser. As we mentioned in a previous chapter, an appraisal can be a powerful piece of evidence. While some grievance consultants are also licensed appraisers, many are not. You might choose to hire an appraiser independently to produce a detailed report on your home's market value, which you then use as the centerpiece of the case you present yourself. Alternatively, a consultant you hire may use the services of an appraiser to strengthen your case. The third type of professional is an attorney. While some attorneys also handle the initial administrative grievance, their role becomes most critical if you decide to appeal the board's decision in court. As we discussed in the last chapter, filing for a small claims assessment review, SCAR, or a tax certiorari proceeding is a formal legal action. An attorney can ensure that the court petition is filed correctly, that all legal deadlines are met, and that all parties are properly served. They will represent you before the court-appointed hearing officer or judge, presenting your case according to the more formal rules of a judicial proceeding. For the complex tax certiorari process, legal representation is almost always a necessity. So, how are these professionals compensated? The fee structures can vary, but there are a few common models. The most prevalent in this field is the contingency fee. In this arrangement, the professional's fee is a pre-agreed percentage of the property tax savings they achieve for you for the first year. The key feature of a contingency fee is that if they do not win a reduction for you, you owe them nothing for their services. This no-win, no-fee model is attractive to many homeowners as it minimizes upfront financial risk. Another option is a flat fee. Here, you pay a fixed amount for the service, regardless of the outcome of your case. This provides certainty about the cost from the outset. Less common for initial grievances, but sometimes used, especially by attorneys, is an hourly rate, where you are billed for the actual time the professional spends working on your case. Whatever the arrangement, it is crucial to get a clear, written agreement that details all fees and any potential additional costs, such as appraisal fees or court filing fees, before you formally engage their services. The decision to hire a professional involves weighing the potential benefits against the costs. The primary benefits are expertise, convenience, and time savings. A professional understands the nuances of the system and can potentially build a stronger case than a novice. On the other hand, the primary reason to handle it yourself is to save on costs. If you win a reduction on your own, you keep 100% of the tax savings. In conclusion, you have the right to represent yourself throughout the administrative grievance process. However, tax consultants, appraisers, and attorneys offer specialized knowledge that can be beneficial, particularly in complex cases or in the judicial appeal stage. Understanding their roles and fee structures allows you to make an informed decision that is right for you. In our next chapter, we will highlight some of the common pitfalls and mistakes homeowners make during the grievance process, and how you can avoid them. Thank you for listening. Hello and welcome back to our educational series on the property tax grievance process. By this point, we have covered the fundamentals, the evidence, the filing procedures, and the role of professionals. In this chapter, we will focus on the other side of the coin, the common pitfalls and misunderstandings that can weaken an otherwise valid case. By understanding these common errors, you can better navigate the process and present your argument more effectively. Before we proceed, we must provide our standard, yet crucial, disclaimer. This information is for educational purposes only and does not constitute legal, financial, or tax advice. It is a general overview of common issues. Every case is unique, and local procedures vary. For advice specific to your situation, please consult with a qualified professional. One of the most significant and irreversible errors is misunderstanding the nature of the filing deadline. We mentioned this in a previous chapter, but it bears repeating due to its absolute importance. The filing deadline or grievance day is not a suggestion, it is a legal statute. There are no extensions for forgetting or being busy. Missing it means you forfeit your right to appeal for the entire year. It is a common misconception that a phone call or an informal letter is enough to start the process. It is not. A formal application must be physically or electronically received by the proper office by the close of business on that final day. The second, and perhaps most frequent, conceptual mistake is arguing about high taxes instead of the property's assessment. Homeowners are often understandably frustrated by the size of their tax bill. However, the Board of Assessment Review has absolutely no authority over tax rates. Complaining about the school budget, municipal spending, or the fact that your taxes went up is an ineffective argument that will fall on deaf ears. Your entire presentation must be laser-focused on one thing: providing evidence that your property's assessed value is incorrect. The hearing is a discussion about value, not a forum for civic budget debates. Another major pitfall lies in the evidence itself, specifically, using poor or irrelevant comparable sales. Not all sales are created equal. To be persuasive, your comps must be truly comparable. A common mistake is to select homes that are not similar enough. For instance, using a sale of a ranch-style home to value a two-story colonial, or a home in a different school district or neighborhood. Another error is using sales that are too old. Market conditions change, so a sale from 2 years ago is much less compelling than one from the last 6 months. Furthermore, it is important to avoid using non-arm's length transactions as evidence. These are sales that were not on the open market, such as a foreclosure, a sale between family members, or an estate sale, as they often do not reflect the true market value of a property. Tied to this is an over-reliance on unofficial online estimates. Websites like Zillow and other real estate portals provide automated valuation models, which can be a useful starting point for a homeowner's own research. However, these are computer-generated estimates, not formal appraisals. They can be based on inaccurate data and do not carry the same weight as a thoroughly researched comparable sales analysis or a professional appraisal. While you can include such estimates as a supplementary piece of information, they should never be the foundation of your case. A fifth common mistake is submitting an incomplete or disorganized application. The members of the review board are often volunteers who have to review dozens, if not hundreds, of cases in a short period. An application that is incomplete, difficult to read, or has evidence that is poorly organized makes their job harder and reflects poorly on your case. Ensure every section of the form is filled out. Label your attachments clearly. Present your evidence in a logical, easy-to-follow manner. A clean, professional-looking submission demonstrates that you are serious and have a well-thought-out argument. Next, we have the pitfall of adopting an emotional or adversarial demeanor. It is natural to feel passionate about your home and your finances. However, expressing frustration or anger during a hearing is counterproductive. The assessor and the board members are professionals doing their jobs. A respectful, calm, and fact-based presentation is far more persuasive. Treat the hearing as a business meeting where you are presenting a factual case, not as a personal confrontation. Finally, a simple but surprisingly common error is making factual mistakes on the application form itself. This could be as simple as writing down the wrong parcel ID number, or misstating a key fact about your property. Such errors can, in some cases, be grounds for the board to reject your application on a technicality before they even consider its merits. Double-check and even triple-check every piece of information on the form for accuracy before you sign and submit it. By understanding these common pitfalls, from missing the deadline to using weak evidence, you can present a more credible, professional, and ultimately more persuasive case. In our next chapter, we will take a deeper dive into the heart of most grievance cases: how to select and analyze strong comparable sales. Thank you for listening. Hello and welcome back. In our last chapter, we discussed common pitfalls in the grievance process, and one of the most significant was using weak or irrelevant comparable sales. Because comps are the evidentiary backbone of the vast majority of successful property tax grievances, this chapter is dedicated to taking a much deeper dive into what makes a comparable sale strong, credible, and persuasive. Before we dissect this crucial topic, we must begin with our standard disclaimer. This is an educational guide intended to explain the principles of property valuation for the purpose of a tax grievance. It is not real estate, appraisal, or legal advice. The selection and analysis of comparable sales is a nuanced process. For a definitive valuation or for guidance on your specific case, please consult with a licensed appraiser or a qualified tax grievance professional. First, let's establish a key term: the subject property. In any valuation analysis, the subject property is your home, the property that is the subject of the grievance. The entire goal of a comparable sales analysis is to find other properties that have recently sold and are as similar to the subject property as possible, in order to justify your opinion of its value. So, what are the key ingredients of a strong comparable property? Think of it as a series of filters you apply to find the best matches. The first and most important filter is proximity. Real estate is all about location, location, location. A strong comparable property should be as physically close to your home as possible. Ideally, it will be in the same neighborhood, subdivision, and critically, the same school district. The value of a home is heavily influenced by its immediate surroundings, the quality of the schools, proximity to parks, or nearness to a noisy highway or a commercial district. A home located a mile away might as well be in a different world from a valuation perspective if it's in a different school district or a neighborhood with a vastly different character. The second filter is the timing of the sale. The property market is dynamic. Values can rise or fall over time. Therefore, the more recent the sale, the more relevant it is as an indicator of current market value. Most assessment boards want to see sales that occurred as close as possible to the official valuation date set by your municipality. A sale from 3 years ago is of very little use. A sale from within the last year is better, and a sale within the last 6 months is ideal. The third filter is physical similarity. This is where the details really matter. A strong comp should be physically similar to your subject property across several key metrics. This includes the architectural style. A ranch is not a good comparable for a 2-story colonial. It includes the gross living area, or square footage. While they don't have to be identical, a 1,500 square foot home is not a good comp for a 3,000 square foot home. You should also look for similarities in lot size, the age of the home, and the basic layout, such as the number of bedrooms and bathrooms. The more these core features align, the stronger the comparison. The fourth filter involves features and condition. Look for properties that share similar features with yours. Does your home have a 2-car garage, a finished basement, and central air conditioning? If so, your ideal comps will have them too. Conversely, if your home lacks these features, comparing it to a home that has them is not an apples-to-apples comparison. The overall condition of the property is also paramount. An ideal comp is in a similar state of repair as your subject property. A home that was recently renovated with a brand new kitchen and bathrooms is not a fair comparison to a home of the same age with all original, dated fixtures. Once you have identified a few potential comps that pass these filters, the next step is a more nuanced analysis involving the concept of adjustments. This is a technique used by professional appraisers to account for the minor differences that will inevitably exist between properties. The idea is to adjust the sale price of the comparable property to make it even more like your subject property. Here's a simplified example. Suppose the comparable property sold for $500,000, but it has a swimming pool, and your subject property does not. A professional would estimate the value of that pool. Let's say it's $25,000, and then subtract that amount from the comp sale price. The adjusted sale price of the comp would then be $475,000, making it a more accurate indicator of your own home's value. Adjustments can be made for many differences, such as an extra bathroom, a finished basement, or a superior location. This is a complex part of valuation, but understanding the concept helps you select comps that will require the fewest and smallest adjustments. Finally, how you present this information matters. Don't just submit a list of addresses and sale prices. The most effective way to present your analysis is in a grid or chart format. The first column should list the key features of your subject property. Subsequent columns should detail each of your comparable properties, with the sale price at the top. This allows the review board to see, at a glance, a direct, side-by-side comparison of your home against the properties you believe prove its value. In summary, selecting strong comps is a methodical process of filtering by location, sale date, physical characteristics, and condition. The goal is to find sold properties that are so similar to your own that their sale prices provide a compelling argument for your home's true market value. In our next chapter, we will discuss what happens after you've won a grievance and how that reduction impacts your taxes now and in the future. Thank you for listening. Hello and welcome back. In our previous chapters, we've journeyed through the entire tax grievance process, from filing the application to presenting your case. Let's now turn to the positive outcome you've been working for. You've received a notice of determination in your favor, and your property's assessment has been reduced. What happens now? This chapter will explain how that reduction translates into actual tax savings, and what you can expect to see on your future bills. Before we explore the financial impact, we must begin with our essential disclaimer. This chapter provides general information for educational purposes about the effects of an assessment reduction. It is not financial or tax advice. The exact calculation of your tax savings will depend on your specific local tax rates and billing cycles. For specific financial advice, please consult with a qualified financial advisor or tax professional. The first and most important concept to understand is that a reduction in your assessment is not a direct dollar-for-dollar refund. It is a common misconception that if your assessment is lowered by, for example, $50,000, you will receive a check for that amount. That is not how it works. The assessment is simply the value upon which your taxes are calculated. The savings come from applying the local tax rates to a smaller value. The basic formula is straightforward. The amount of your assessment reduction is multiplied by your total property tax rate to determine your approximate annual savings. Remember, your total tax rate is often a combination of several different rates: a school tax rate, a town or city tax rate, and a county tax rate. Let's use a purely illustrative example to make this clear. Imagine your property's assessment was reduced by $50,000. And let's assume the combined tax rate in your area is $30 per $1,000 of assessed value, which is equivalent to a rate of 3%. To find the annual savings, you would multiply the $50,000 reduction by 3%, or 0.03. The result would be an annual tax savings of approximately $1,500. Your specific savings will depend entirely on your own numbers. The next logical question is, when will I see these savings? The reduction is not retroactive to taxes you have already paid. The change is made to the final assessment roll, which is then used to generate the future tax bills. For example, if you win your grievance in the spring, you will likely see the savings reflected on the school tax bill that comes out in the fall and the town and county tax bills issued the following year. It is a forward-looking benefit. Another common question is, how long does this reduction last? Generally, the new lower assessment becomes your property's baseline value moving forward. It will typically stay at or near that level until a major event prompts a reassessment. Such an event could be a town-wide or county-wide revaluation, where every single property is reassessed. It could also be triggered by physical changes to your property, such as building a major addition. So, while it is not guaranteed to be permanent, a successful grievance effectively resets your assessment to a more accurate level for the foreseeable future. For the many homeowners who pay their property taxes as part of their monthly mortgage payment, the reduction will also affect your escrow account. Your mortgage lender or servicer maintains this account to collect funds from you each month to pay your property tax and homeowners insurance bills on your behalf. When you receive your new lower tax bills, you should forward a copy to your mortgage servicer. At least once a year, your servicer is required to perform an escrow analysis. They will review the amount they've collected against the actual amount paid out for taxes and insurance. When they see that your tax liability has decreased, they will adjust the escrow portion of your monthly mortgage payment downward. This means your total monthly payment will be lower. Additionally, this analysis may reveal that you have an overage or surplus in your escrow account because you were paying in at the old, higher rate. Depending on the servicer's policy and federal regulations, this surplus may be refunded to you in a check or credited toward your future mortgage payments. Finally, once you receive the decision, it is a good practice to follow up. When the final assessment roll is published, verify that your property's value is listed at the new, reduced amount. When you receive your subsequent tax bills, double-check that they have been calculated using the correct, lower assessment. Mistakes can happen, and a little diligence ensures you receive the full benefit of your successful grievance. In summary, winning a grievance leads to real savings by reducing the taxable value of your property. These savings will appear on future tax bills and will likely result in a lower monthly mortgage payment if you have an escrow account. In our next chapter, we'll shift our focus slightly to another important way to manage property tax costs: understanding and applying for property tax exemptions. Thank you for listening. Hello and welcome back to our comprehensive series on property taxes. So far, our focus has been on the tax grievance process, the method for challenging the assessed value of your property. In this chapter, we will shift our focus to an entirely different, yet equally important, tool for managing your property tax burden: property tax exemptions. As we delve into this new topic, our standard disclaimer remains essential. The information provided here is a general educational overview of property tax exemptions and is not financial, legal, or tax advice. Exemption programs, eligibility requirements, and application procedures are determined by state and local laws and vary significantly. You must consult your local assessor's office or a qualified professional to determine which exemptions may be available to you and to verify the specific criteria. So, what exactly is a property tax exemption? An exemption is a provision in the tax law that removes a portion of your property's value from taxation. This reduces your property's assessed value, which in turn lowers your tax bill. It is critical to understand the difference between a grievance and an exemption. A grievance is an argument that your property's assessed value is incorrect or unfair. An exemption, on the other hand, is a benefit you receive because you, the homeowner, meet certain specific criteria based on factors like your age, income, disability, or military service. You are not arguing about the market value of your home. You are claiming a legally mandated benefit. Many states and municipalities offer a wide variety of exemption programs. Let's discuss some of the most common types. Perhaps the most widespread is the homestead exemption. This is a general exemption available in many states for an individual's primary residence. It is designed to provide a measure of tax relief to all homeowners, as opposed to just a specific group. The name and the amount of the benefit vary greatly. For example, in New York, this type of benefit is known as the STAR program. To qualify, you must own and live in your home as your primary residence. Another very common category is the senior citizen exemption. Recognizing that many older adults are on fixed incomes, these programs provide significant tax relief to qualifying seniors. Eligibility is typically based on age. For example, you may need to be 65 or older. Crucially, these exemptions almost always have an income limit. To qualify, your total household income must be below a certain threshold, which is set by the state or local government. Similarly, veterans exemptions are widely available across the country to honor those who have served in the armed forces. The value and eligibility for these exemptions often depend on several factors, including when and where the veteran served. For example, there may be different benefit levels for veterans who served during periods of wartime versus peacetime. Additional benefits are often available for veterans with a service-connected disability, with the amount of the exemption sometimes increasing with the severity of the disability rating. Exemptions are also commonly available for persons with disabilities. These programs are designed to assist homeowners who have a documented physical or mental impairment. Like the senior exemption, these programs often have income limitations and require official documentation of the disability, such as an award letter from the Social Security Administration or a physician's statement. Beyond these common categories, you may find various other exemptions available in your area. Some jurisdictions offer exemptions for the surviving spouses of first responders killed in the line of duty, for clergy members, or for Gold Star parents. There may also be exemptions designed to encourage specific behaviors, such as making your home more accessible for disabled persons, or installing renewable energy systems like solar panels. A critical point to understand is that exemptions are almost never automatic. You must proactively apply for them. This usually involves filling out a specific application form provided by your local assessor's office and submitting it along with any required supporting documentation. For a senior exemption, this might include proof of age and income tax returns. For a veteran's exemption, you would need to provide your military discharge papers, such as a DD-214 form. Just like with grievances, there are strict application deadlines. If you believe you are eligible for an exemption, it is your responsibility to find out the deadline and submit your application on time. Furthermore, some exemptions, particularly those that are income-based.
Disclaimer: this video is for informational and educational purposes only and should not be considered professional legal, financial, or tax advice. I am not a certified public accountant, CPA, or a tax attorney. You should consult with a qualified professional for advice tailored to your individual situation. Tax laws are complex and subject to change. The creator of this video or the channel will not be held liable for any actions taken based on the information provided.
Require you to renew your application each year to re-verify your eligibility. In summary, exemptions are a powerful but separate mechanism from the grievance process for lowering your property tax bill. They are benefits granted based on your status as a homeowner. It is well worth your time to research the programs available in your specific state, county, and town to see if you qualify for these valuable savings. In our next chapter, we will address a frequently asked question. Can you file a grievance if you have recently purchased your home? Thank you for listening. Hello and welcome back to our series on navigating the U.S. property tax system. We've covered many facets of the grievance process, but this chapter will focus on a very common and specific question. I just bought my house. Can I file a tax grievance? This is a situation that millions of new homeowners face, and it presents a unique set of circumstances for challenging an assessment. As we explore this scenario, we must begin with our standing disclaimer. The information provided in this chapter is for general educational purposes only and does not constitute legal, financial, or real estate advice. The weight given to a recent purchase price in a grievance can depend on local rules and the specific facts of the transaction. For advice tailored to your situation, please consult with a qualified professional. For a new homeowner, the first property tax assessment they receive can sometimes be a surprise. You know exactly what you paid for your home just a few months ago, but the assessed value on your notice might be significantly higher. This immediately raises the question, which number is right? The answer is that a recent purchase price can be one of the single most powerful and persuasive pieces of evidence you can present in a tax grievance. The entire goal of an assessment is to estimate a property's fair market value. A recent sale of that very same property on the open market is not an estimate. It is the definition of fair market value in action. It is a real-world transaction between a willing buyer and a willing seller. However, for your purchase price to be considered credible evidence, the transaction must meet a critical standard. It must have been an arm's-length transaction. This is a legal and real estate term that describes a transaction where the buyer and seller act independently and in their own self-interest, without any pressure or duress. An arm's-length transaction has several key characteristics. It takes place on the open market, often with the property being listed publicly. The buyer and seller are not related to each other. For example, a sale from a parent to a child at a discounted price is not an arm's-length transaction. Both parties are well-informed and are under no compulsion to buy or sell. This excludes situations like a foreclosure sale, a short sale, or an estate sale where the seller might be forced to accept a lower price due to financial distress or other circumstances. If your purchase meets these criteria, then your purchase price is a very strong benchmark for the property's value. So, why would an assessor's value be higher than what you just paid in a fair market sale? There are a few common reasons. First, remember the concept of the valuation date. The assessor's value for the entire town or city is fixed on a single date, which could have been 6 months or more before you actually purchased your home. If property values in your area were declining during that period, your purchase price would naturally be lower than the assessor's earlier valuation. Second, assessors typically use a system of mass appraisal to value thousands of properties at once. They use general models and data for neighborhoods. This system is efficient, but it can't be as precise as an individual real-world sale. When you file a grievance based on your purchase price, you are essentially providing the assessor with the most accurate and up-to-date piece of data possible for your specific property, correcting the less precise mass appraisal figure. If you decide to file a grievance as a new homeowner, the evidence you need is straightforward. Your primary document will be your closing statement, also known as the HUD, or more recently, the closing disclosure form. This document officially details every financial aspect of the transaction, including the final sale price. Your signed purchase and sale agreement can also serve as supporting evidence. Furthermore, if you obtained a mortgage to buy the home, your lender most likely required a professional appraisal. If that appraisal valued the home at or near your purchase price, it provides another powerful, independent validation of the value. Even with this compelling evidence, you must still follow all the standard procedures we have discussed in this series. You must obtain and complete the official grievance application form. You must clearly state that the grounds are an excessive assessment based on a recent arm's-length purchase. You must attach copies of your supporting documents, like the closing statement. And most importantly, you must file everything before the strict deadline. In summary, a recent arm's-length purchase price is not an automatic guarantee of a reduction, but it is arguably the strongest evidence a homeowner can have. It provides a clear, market-proven value that is difficult for an assessment board to ignore. In our next chapter, we will briefly touch upon how the grievance process can differ for owners of commercial properties. Thank you for listening. Hello and welcome back. Throughout this series, our primary focus has been on the tax grievance process from the perspective of a residential homeowner. However, the world of property tax is vast, and it includes every type of real estate, from small storefronts to large industrial complexes. In this chapter, we will take a brief look into the different and more complex arena of commercial property tax grievances. Before we begin, it is exceptionally important to state our disclaimer. This chapter provides a very high-level, general overview for educational purposes only. Commercial property valuation and tax appeals are an extremely complex and specialized field of law and real estate. The information here is not a substitute for professional legal and appraisal advice. Any owner of a commercial property considering a tax appeal should engage an experienced attorney and a certified commercial appraiser. While the fundamental right to challenge an assessment is the same for all property owners, the process and the arguments for commercial properties are substantially different and more complicated than for a typical home. The financial stakes are often much higher, and the methods used to determine a property's value are far more sophisticated. For residential properties, the primary method of valuation is the sales comparison approach, which we have discussed at length. While this approach is also used for commercial properties, it can be much harder to apply. Finding recent sales of truly comparable properties can be difficult. How do you find a comp for a unique downtown restaurant, a specialized manufacturing facility, or a large medical office building? The uniqueness of many commercial properties makes a direct, apples-to-apples comparison challenging. Because of this, two other valuation methods become central to commercial property grievances. The first, and often most important, is the income approach. This method is based on the principle that the value of an income-producing property, like an apartment building, an office tower, or a shopping center, is directly related to the amount of income it can generate. An investor purchases such a property expecting a return on their investment. The income approach involves a detailed analysis of the property's financial performance. This includes examining the gross potential income from all rents, subtracting losses from vacancies and collection issues, and then deducting all operating expenses, like property management, insurance, utilities, and maintenance, to arrive at a figure called the net operating income, or NOI. This NOI is then converted into a property value using a figure called a capitalization rate, or cap rate. The cap rate reflects the rate of return an investor would expect for that type of property in that specific market. A higher perceived risk leads to a higher cap rate and a lower property value. The third method of valuation is the cost approach. The theory here is to determine what it would cost to build a modern, equivalent replacement for the existing property from scratch. The analysis starts with the cost of the raw land, adds the current cost of construction for the building, and then subtracts an amount for depreciation. Depreciation accounts for the property's age, physical wear and tear, and any functional or economic obsolescence. The cost approach is often used for unique or special-purpose properties that don't sell often and don't produce income, such as a school, a church, or a new industrial building. Given these complex valuation methods, the evidence required for a commercial grievance is also different. Instead of just a list of comps, the evidence package for a commercial appeal might include detailed rent rolls, profit and loss statements, vacancy rate studies, and sophisticated market analysis reports. The argument is less about what a similar property sold for and more about the property's economic performance or replacement cost. Because of this complexity, the vast majority of commercial property tax appeals are handled by professionals from the very beginning. The process is less of a do-it-yourself endeavor and more of a team effort, typically led by an attorney who specializes in tax certiorari law, working closely with a commercial appraiser who can prepare a detailed, expert valuation report using all three approaches. The appeal process itself is also often more formal, frequently proceeding directly to a judicial setting rather than the informal hearings of a local board of assessment review. In summary, while the goal of a fair assessment is the same, the path for commercial property owners is a specialized journey through complex valuation theories, detailed financial data, and formal legal proceedings. In our next chapter, we will begin to wrap up our series by reviewing the key takeaways and timeless principles of the tax grievance process. Thank you for listening. Hello and welcome back. Over the course of the past 13 chapters, we have embarked on a detailed journey through the American property tax grievance system. we've explored everything from the basic concepts to the nuances of presenting evidence. In this chapter, our goal is to distill all of that information down into a handful of core principles, the key takeaways that form the foundation of a clear and effective approach to the process. As we summarize these key points, please remember our most important message. This series is for educational and informational purposes only. It is not a substitute for professional legal, financial, or tax advice. The property tax system is complex and highly localized. For guidance specific to your property and circumstances, you should always consult with a qualified professional. Let's begin with the first and most fundamental principle. A tax grievance is fundamentally about your property's value, not the amount of your taxes. This is the single most important concept to grasp. The local board you present your case to has no control over tax rates, school budgets, or municipal spending. Your argument must be laser-focused on proving, with evidence, that your property's assessed value is higher than its true market value. Any discussion about your inability to pay or the fairness of the tax burden itself is, for the purposes of this hearing, irrelevant and ineffective. The second core principle is that the calendar is king, and deadlines are absolute. The entire property tax system, from assessment to appeals, runs on a strict, legally mandated schedule. The deadline to file your grievance is not a suggestion. If you miss it, you lose your right to appeal for that entire tax year. There are no extensions. It is the property owner's personal responsibility to know the specific, critical dates in their jurisdiction for filing both grievances and exemption applications. Our third principle is that evidence is the language of the process. A successful appeal is not one on opinion or emotion, it is one with facts. Your case must be built on a foundation of credible, objective evidence. This starts with the basics, ensuring your property record card is accurate and free of factual errors. It then extends to the heart of most cases, presenting well-researched, truly comparable sales that demonstrate your property is overvalued. In some cases, a professional appraisal provides the expert opinion needed to solidify your claim. A case with strong evidence speaks for itself. The fourth key takeaway is that all property tax is local. While we have discussed the process in general terms, the reality is that the specific rules, forms, board names, and procedures are determined at the state, county, and municipal levels. The process in Texas is different from the process in New York, and the rules in one Ohio county may differ slightly from the next. You must research the specific procedures for your local assessing unit. Their website and office are the primary sources for the correct forms and local timelines. Fifth, professionalism and preparation are persuasive. Your demeanor and organization have a significant impact on how your case is perceived. A presentation that is calm, respectful, clear, and well-organized will always be more effective than one that is emotional, disorganized, or adversarial. Remember that the board members and the assessor are people doing their jobs. Treating them with courtesy and presenting your factual argument in a logical manner makes it easier for them to understand and fairly consider your position. Our sixth principle is to understand the multi-stage path of an appeal. The process is typically layered. Your first formal step is an administrative review before a local board. This is designed to be accessible to the average citizen. However, if you are not satisfied with that outcome, you generally have the right to a more formal judicial review, such as a small claims assessment review or a tax certiorari proceeding. Knowing that this next level of appeal exists is part of understanding your full rights in the process. Finally, remember that grievances and exemptions are two different tools in your toolbox. A grievance challenges your home's value. An exemption is a benefit that reduces your assessed value based on your status, such as being a senior, a veteran, or a person with a disability. It is entirely possible to pursue both. By keeping these core principles in mind, you can navigate the property tax grievance process with greater clarity and confidence. In our final chapter, we will offer some concluding thoughts on being a proactive and informed homeowner. Thank you for listening. Hello, and welcome to the final chapter of our educational series on the property tax grievance process. We have traveled a long road together, from defining a simple property tax to navigating the complexities of judicial appeals. Our goal throughout this journey has been to demystify a system that can often feel intimidating, and to empower you with knowledge. In this concluding chapter, we will step back and reflect on what it means to be a proactive and informed homeowner in the context of property taxes. Before we offer our final thoughts, it is imperative that we state our most important message one last time. This entire series has been produced for general educational and informational purposes only. It is not, and was never intended to be, a substitute for professional legal, financial, or tax advice. property tax law is intricate and varies immensely by location. To address your specific situation, you must consult with a qualified, licensed professional who can provide guidance based on your unique circumstances and the laws in your area. The tax grievance process is more than just a procedure to potentially lower a bill. It is a fundamental right that serves as a check and balance within the property tax system. It ensures that the tax burden is distributed equitably, based on fair and accurate valuations. Understanding this process is a key part of responsible homeownership. The most valuable habit you can develop from the information we've shared is that of annual review. Think of reviewing your annual assessment notice not as a chore, but as a form of routine financial maintenance, just like balancing your checkbook or reviewing your credit report. When that notice arrives in the mail each year, don't just glance at the numbers and file it away. Take a few moments to actively engage with it. Ask yourself, does this assessed value seem to reflect the current market value of my home? Have I checked my property record card recently for errors? Am I taking advantage of all the exemptions for which I am eligible? This simple, annual check-in can help you identify potential issues long before they become significant problems. Being an informed homeowner also means understanding the why behind your property taxes. As we mentioned in our very first chapter, these taxes are the lifeblood of your local community. They pay for the teachers in your public schools, the firefighters and police officers who keep you safe, the plows that clear your roads in the winter, and the parks where your children play. While no one enjoys paying taxes, understanding their direct connection to the quality of life in your neighborhood provides crucial context. A fair assessment ensures you are paying your fair share, no more and no less, for these essential services. Throughout this series, we have armed you with a new vocabulary. Terms like assessed value, comparable sales, arm's length transaction, and Board of Assessment review. This knowledge is power. It allows you to read your assessment notice with comprehension, to ask intelligent questions of your local assessor's office, and to understand your rights and responsibilities as a taxpayer. It transforms the process from something mysterious and opaque into a series of logical steps that you have the ability to navigate. The ultimate takeaway from this series is not that you should challenge your assessment every year. Rather, it is that you have the right to do so, and you now have a foundational understanding of how that process works. You know that a successful grievance is not based on emotion, but on well-researched, factual evidence. You know that deadlines are critical, and that the entire process is built on the principle of proving your property's true market value. Being a proactive homeowner means engaging with your responsibilities and rights with confidence. It means keeping good records, staying aware of your local real estate market, and knowing where to turn for official information and professional advice when you need it. The property tax system is a partnership between citizens and their local government. By being an informed participant in that system, you not only look out for your own financial interests, but also contribute to the fairness and integrity of the process for everyone. Thank you for joining us on this educational journey. We hope this series has been a valuable resource and has empowered you with the knowledge to be a more confident and informed homeowner.
Disclaimer: this video is for informational and educational purposes only, and should not be considered professional legal, financial, or tax advice. I am not a certified public accountant, CPA, or a tax attorney. You should consult with a qualified professional for advice tailored to your individual situation. Tax laws are complex and subject to change. The creator of this video or the channel will not be held liable for any actions taken based on the information provided.